Hey guys, so we're going to try to live stream this hearing for Chad Daybell. If I can find it. I mean, I've got it pulled up. Let me see. Let me ask the ladies in Discord if I'm on the right video. One sec, guys. Cement Cheese, Candy, Karen. Hey, guys. So I got this video pulled up, and it's, let me share it with y'all. Let me show y'all what I'm seeing. Hey, Tina. Okay, guys, this is what I'm seeing. It says, watch live at 11 a.m. Mountain Time, Chad Daybell to appear in court after human remains of 2 bodies found. This is what I'm seeing. Oh, my goodness. There's like no audio, but everyone's in there chatting. I'm popping over. Oh, okay. I was reading the Discord. Sorry, I about forgot I was live. So I guess we'll just have to give it a see.
Okay, so yesterday you got there in the afternoon to Rexburg. And you, as that search was going on, there were roads blocked off for, I think you said, a mile or two all around the search scene.
We get in trouble. We get in trouble, guys.
Situation. Were they able to tell you why it was blocked off in such a wide area?
They didn't go into specifics. That's one of those things that, police yesterday weren't taking a lot of questions. They were being pretty tight-lipped with a lot of things. But, again, a couple of miles in each direction from his house. And keep in mind, we are here in Fremont County. It's a very rural roads, a lot of houses out there, but very spread out. And so based on where we were, we drove all the way around trying to find a road that would get us as close
I'm sorry,
as
Misty. I'm gonna have to cut you off right there because the hearing is actually starting now. I know you want to listen in as well, so let's also listen in Chad Daybell's initial court appearance.
Your Honor, I'm going to mute my mic and turn off my camera, but I'm not leaving the meeting. I'm right here.
Here we go, guys. I'm just going to be quiet. I got to go in the kitchen. I'll be back.
Judge, we're going to do the same as well.
All right. We're only going to be about a minute and a half, and then I'll start.
Gosh, I've not got a thing done today, guys, here. Is it still playing? You're welcome, Karen. Thank you guys for being here. Yeah, I wonder how he likes those prison stripes,
As you heard
Jamie.
There, Judge Farron Edens was giving the prosecution and
all right, we're going to call it the case.
About a minute and a half. That went pretty quickly. Let's listen in.
One moment.
More evidence of the times that we are living in right now. So many things happening by Zoom and teleconferencing. And as you see, the judge and a clerk are the only ones in the Fremont County courtroom right now. The prosecutor, Rob Wood, up there in the upper right-hand corner, is remotely patching into this hearing, as well as Chad Daybell there in the left in the prison outfit, or the jail outfit, I should say, and his attorney, John Pryor, waiting for this to get started as the judge sets things in place. No
I'm gonna go on the
reporters, no
record. Good
public
morning
allowed
here.
in the courtroom either.
In Fremont County, Idaho. This is the case of CR 2220-755, State of Idaho versus Chad Guy Daybell. This matter is being held at the Fremont County courtroom via Zoom remotely. Mr. Daybell, the defendant, appears with his counsel, Mr. Pryor, at the jail here in Fremont County. Mr. Wood appears remotely from his office. There is the clerk here, there's a court reporter, and there is some IT support that is also on the line. This is the date and time set for an initial appearance. The reason we're holding this hearing remotely via Zoom is due to a order that's been issued by the Supreme Court. In that order, it designates that whenever plausible, hearings are to be held remotely in order to effectuate safety of society and effectuate safety of all employees in the courtroom. In future proceedings, it will be an issue that's addressed case by case and hearing by hearing. That order is dated April 22nd, 2020, and has been issued by the Idaho Supreme Court. Mr. Daybell, do you read, speak, and understand the English language?
Yes.
No,
Mr. Daybell, can you hear me okay
I
today?
don't.
Yes.
Mr. Daybell, it appears that you have hired private counsel, Mr. John Pryor. Is that correct?
Yes.
And you'd like to retain him. Mr. Pryor, has there been a formal notice of appearance that has been entered?
Judge, I will get that filed within a short period of time.
All right, but Mr. Daybell, Mr. Pryor is your attorney for this hearing. Is that correct?
Yes.
Mr. Daybell, have you seen a notification of rights form that was provided to your counsel prior to the hearing here today?
Yes.
Do you understand all of your legal rights?
Yes.
Mr. Daybell, in addition to the rights that were contained in that notification of rights form that was given to you, I'm going to advise you of additional rights under Idaho Criminal Rule 5. Number one, you have the right to be at the initial appearance or appear via Zoom remotely like you are today. You don't need to make any statements today. You have the right to know what charges are being brought against you. You have the right to bail. You have the right to counsel. And you have all of the other rights that have been presented to you in that notification of rights. Do you have any questions about your rights, Mr. Daybell? I didn't hear your answer.
No. He does not.
You understand your legal rights. Is that correct?
I do.
All right. Mr. Daybell, did you receive a copy of the warrant of arrest as well as the criminal complaint that has been filed here in Fremont County in this case?
Yes.
Mr. Daybell, have you had a chance to review that criminal complaint as well as the arrest warrant with your counsel?
Yes.
Mr. Pryor, I can read the criminal complaint in its entirety, or I can summarize it for you.
Judge, we'll waive actually formal reading of the criminal complaint at this time, and I've discussed that matter with Mr. Daybell, and we're ready to proceed forward without either a summary or a formal reading at this point.
All right. The court is going to summarize briefly what the charges are, so that that's on the record, and then we'll address the other issues we need to address. Let me get one more thing out of the way, Mr. Pryor. Ultimately, the Supreme Court order has ordered these hearings be held remotely, but it's my understanding your client is willing to waive his right to be here in court in person. Is that correct?
It is, Your Honor. Thank you.
Okay. Mr. Daybell, is that also correct?
Yes.
With regards to the criminal complaint, it was filed dated June 10th, 2020. There are 2 counts in the criminal complaint. The first count is destruction, alteration, or concealment of evidence, a felony, a violation of Idaho Code 182603. The maximum punishment for that charge is up to 5 years in the state penitentiary and or up to a $10,000 fine. The allegation is that the defendant, Chad Guy Daybell, on or between the 22nd day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully conceal and or aid and abet another to willfully conceal human remains, knowing that said human remains were about to be produced and used and or discovered as evidence in a felony proceeding, inquiry and or investigation authorized by law with the intent to prevent it from being so produced, used, and or discovered. Count 2 is also the same charge, destruction, alteration, or concealment of evidence, a felony. It's punishable by up to 5 years in the state penitentiary and or up to a $10,000 fine. It alleges that the defendant, Chad Guy Daybell, on or between the 8th day of September 2019 and the 9th day of June 2020 in the county of Fremont, state of Idaho, did willfully destroy, alter, and or conceal human remains, and or did aid and abet another to willfully destroy, alter, and or conceal human remains, knowing that said human remains were about to be produced, used, and or discovered as evidence in a felony proceeding, inquiry and or investigation authorized by law with the intent to prevent it from being so produced, used, and or discovered. Mr. Daybell, do you understand the allegations on both accounts that have been brought against you?
I do.
Mr. Daybell, do you also understand the maximum penalties on each of those counts?
Yes.
Mr. Daybell, do you understand that those maximum penalties could run consecutively, one after the other, or they could run concurrently? Do you understand that?
Yes.
All right. We've gone through the criminal complaint. We've gone through each count. I've advised the defendant of his right. We've gone through that form. Let's discuss the next hearing that's going to be set. Mr. Pryor and Mr. Wood, that next hearing would be a preliminary hearing or a probable cause hearing. The defendant has a right to have that within 14 days if he's incarcerated. It's my understanding that based upon previous conversations that there'll be a waiver of that speedy preliminary hearing. Is that correct, Mr. Pryor?
It is, Your Honor. I've had that discussion with Mr. Daybell. In addition, I've had that discussion with Fremont County prosecuting attorney, and at this point, we'll waive the time.
Mr. Wood, is that correct as far as the stipulation?
Yes, the state's fine with that, Your Honor.
Mr. Pryor, the court's going to grant that waiver and acknowledge that it's knowingly and voluntarily made, but I will need a written waiver of speedy preliminary hearing so that can be in the file for the record. Do you understand?
Yes, Your Honor. I'll do that. Thank you.
All right. With regards to a preliminary hearing, let's first talk about the logistics of that. Mr. Wood, how long do you foresee it taking to accomplish a preliminary hearing in the future?
No longer than a day.
Okay. 1 day. Mr. Pryor, do you concur with that?
Judge, I'm at a little bit of a disadvantage, but for practical purposes, I think a day would be appropriate.
All right, we'll set this for 1 day. Mr. Wood and Mr. Pryor, do you have a timeline that you'd like to look at as far as scheduling that today?
Judge, my preference would be within 4 to 6 weeks.
Mr. Wood?
That's fine. We do have a preliminary hearing on July 9th and 10th in the Lori Vallow case. And so if we are going to push it out that far, I'd ask that this prelim be at least the week of the July 16th.
Unfortunately, I'm going to be out of town the week of July 16th, and I won't be back for some time. So if we need to have it in July, it probably needs to be towards the beginning of July or into June. Otherwise, it's going to have to be the last week of July. Mr. Pryor, does that work with your schedule?
Judge, the latter part of June and the first week of July, the 1st and the 2nd of July would be ideal for me if that's available to the court and to Mr. Wood.
We can make that work.
All right, let's look at dates then. I'm looking at the calendar. The end of June, it looks like those Monday is the 29th, and then Tuesday is the 30th, and then Wednesday is July 1st, Thursday, July 2nd. Which of those days do both of you prefer?
I think the 2nd would be best for the state.
Mr. Pryor, does that work for you?
Judge, I believe the 2nd falls on a Friday, if I'm not mistaken. So I would like to see if we could do the 1st, and if necessary, we can have the 2nd available in the event this thing runs a little longer, Your Honor.
Okay, so the 2nd is a Thursday, Mr. Pryor, but I appreciate that you would like to have extra time if it does go over. So if we set it for the 1st, Mr. Wood, can we do that? And then if it spills over into the 2nd, we'll make sure that date's available.
That'd be fine.
Okay. We'll set that then July 1st and July 2nd for the preliminary hearing or the probable cause hearing. Lastly, the court has issued the arrest warrant. The court designated that it would address bond and or bail at the hearing set today. And so I'd like to hear argument from both parties regarding bail. So why don't I hear from the state first, and then I'll hear from the defense.
Thank you, Your Honor. The state is requesting the bail to be set at $1 million. While we recognize that felony concealing of evidence only has a maximum sentence of 5 years per charge, I think the background and context of this case necessitates a higher bail. One of the primary reasons we are asking that bail be set in that amount is that the evidence that has been concealed in this case, it's not simply a document, drugs, a gun. These are human remains. And we can, although those remains have not yet been positively identified, we are aware that those remains are the remains of children, which we believe is an aggravating factor.
Wow.
We have asked that the probable cause affidavit be sealed, but I would ask the court to take note of paragraphs 39 and 40 and the manner of the concealment of one of those bodies, which the state finds to be particularly egregious, both an aggravating factor and bears on character, as Rule 40 as Rule 46 allows us to look at. Your Honor, we understand that the possible sentence on this case is not that long, but knowing what the subject matter is, we find it extremely serious. And we would also note that because of what has been found on Mr. Daybell's property, should he bail out, he has strong incentive to flee. Clearly, this is the beginning now of an investigation into the deaths of children who are found on his property, and so that provides a strong incentive to flee, and we would ask that the bail reflect that. Whatever the court sets as bail, we would ask that the conditions be set that should he bond out, that he be required to wear an ankle monitor, and that he be...
Hell no, he don't need to bond out. Froze up.
Thank you, Mr. Wood. Mr. Pryor, I'll hear from you next.
And Judge, for just for purposes of the record, my understanding is the court's allowing us to address this issue of bond, but that in no way limits us in the future to file a further motion for bond if that's necessary. And I believe that's the court's understanding, Mr. Wood's understanding as well, is not, Judge?
Let me make that clear for the record. Because of the nature of timing and such, generally speaking, the court sets a bail based upon a probable cause affidavit, and then if a motion needs to be filed after, it can be filed. I did not set a bail because, frankly, it was timing. And so, correct, Mr. Pryor, I'm going to give you complete ability to file a renewed motion or a first motion to deal with bail. I guess de novo is how you could look at that. And so I'm going to set bail today. When you file your motion, the court will definitely give you a hearing for that, and we'll take it and make a decision based upon that.
Thank you, Your Honor. But in regards to argument, Your Honor, I would point out that the charges are, as Mr. Wood pointed out, carry a maximum of 5 years. Mr. Daybell is not charged with anything more serious. And quite honestly, for the prosecuting attorney to assume that in the future he may or may not do that, and that we should increase the bail with the idea that in the future there may be something else coming down the pipe is just clearly contrary to what the purpose of bail is. Bail is to assure that Mr. Daybell shows up to court. Bail is to assure that he's not a flight risk, and there's nothing, in, as far as I'm concerned, in his history that indicates that he's going to flee the jurisdiction. I would refer the court to the affidavit on number 26, and it talks about the last time that they saw the kids. If Mr. Wood's intention is to pursue further charges, my belief is that he would have pursued those. And quite honestly, at this point, the court needs to take consideration of what the current charges are and whether or not Mr. Daybell will show up to court. Mr. Daybell has taken the initiative to hire private counsel. He has shown up to the proceeding today. Obviously, he's in custody. But Judge, when the police showed up at his house last night, Mr. Daybell didn't flee. Mr. Daybell didn't abscond. Mr. Daybell didn't run.
He couldn't.
Mr. Daybell's intention was, through his counsel, to turn himself into the court if that was something that was going to happen and address these issues. He has every intention of addressing these issues. He has significant family in the community. He has kids that live here. He owns property here. And quite honestly, I disagree with Mr. Wood. Mr. Daybell has every intention of staying in the community and every motivation to stay in the community and address these charges. So at this point, Judge, I would ask the court to put the bail at an amount that's appropriate for a 5-year felony sentence. I understand that there's been a significant amount of publicity with this, but publicity is not a reason to raise the bail to an extraordinary amount. And I would suggest that Mr. Wood's suggestion that a $1 million bail is okay. It's not okay, Judge. A $1 million bail is not okay for a 5-year felony sentence. And if in the future Mr. Wood decides to pursue other charges, I'm sure we'll address this again. But at this point, Your Honor, I think it's important for the court to set a bail at an appropriate amount based on the 2 felony 5-year sentences. I would ask the court for $50,000 on each count for a total of $100,000, Your Honor.
Thank you, Mr. Pryor. The court has listened carefully to the argument of both parties. The court has reviewed Idaho Criminal Rule 46, specifically the factors contained in Idaho Criminal Rule 46 under subsection C. There are 10 different factors that the court has looked at. The court has also looked carefully at Idaho Code 192904 and the factors that are designed therein. In looking at the factors in 192904, there are 4 specifically that the legislators have set forth. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court is cognizant that there is an absolute constitutional right to bail provided in both the Idaho Constitution and the U.S. Constitution. The court has taken all of those factors into account, and based upon those factors and the charge, the court is going to set bail in the amount of $1 million. The court notes that the charge is destruction, alteration, and concealment of evidence as pertained in the criminal complaint. I've taken all those factors into account. Specifically, the factor in Rule 46C, subsection 6, which designates I'm to take into account the nature of the current charge and any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. The underlying charge here is destruction, alteration, and concealment of evidence, and the allegation is that the evidence was human remains of 2 different people. That's an aggravating fact, and the court has taken that into account. If bail is posted, Mr. Pryor, I'm also going to make conditions of bail. Those conditions will be as follows. Number one, I'm going to order that a waiver of extradition be provided to the Fremont County Office of the Sheriff. The prosecutor must approve the waiver of extradition by his signature on the waiver of extradition. A copy of that waiver must be filed with the court. Number two, I'm going to order that the defendant shall reside within the boundaries of Bonneville, Jefferson, Madison, and Fremont counties in the state of Idaho. The defendant shall not leave these counties for any reason. Number three, the defendant shall provide the court with his current address and shall not change his address without notifying the court. Number four, the defendant shall keep in regular contact with his attorney. Number five, the defendant shall appear for all court appearances. Number six, the defendant shall obey all laws of the state of Idaho and the United States of America. Number seven, the defendant will sign up for pretrial services and check in with pretrial services here in Fremont County on a weekly basis, as directed. The defendant shall have absolutely no contact with the victims' families and or any of the state's witnesses in this case. Contact shall include, but be not limited to, verbal contact, written contact, visual contact, text messaging contact, email or internet contact, and or telephonic contact. Such contact shall also include contact through third parties. Number nine, the defendant must wear an ankle monitor 24 hours a day, 7 days a week. He must have the ankle monitor in place before he is released from the Fremont County Jail. Any violations of the geographical limitation imposed herein must be reported immediately to the Fremont County Sheriff's Office and the court. If the defendant is notified that under the order to wear the ankle monitor, intentionally leaving the area of restriction, except for the purpose of obtaining emergency medical care, may be prosecuted as a crime of escape and subject the defendant to penalties under Idaho Code. If the defendant fails to comply with all of these terms, the court may, pursuant to Idaho Criminal Rule 46I and Idaho Code Section 2919, revoke the defendant's release and eligibility for posting of bail. Mr. Daybell, Mr. Pryor, do both of you understand what bail has been set at, as well as any conditions that must be met in order for that bail to be set?
Yes, Your Honor. Yes.
Mr. Wood, any questions?
No, thank you, Your Honor.
All right, we will we'll be in recess for today, pending that preliminary hearing. There will be a few things that need to be worked out, and we're going to go off the record for now, and I'll see everybody back here at the beginning of July. Council will have to communicate regularly, both with the court and with each other, about how this hearing is going to be held, whether it's going to be held remotely or whether it's going to be held in person. Mr. Wood or Mr. Pryor, do either of you wish to address that issue today?
Not today, Judge.
No, and I can, Mr. Pryor and I can visit and talk about that and see if we can come to an arrangement before we address that issue with the court.
All right, I will just state for the record that the court will need to make findings if we're going to do it live in person, and we'll address that at a future hearing on whether or not that's going to take place. With that, we'll be in recess. Thanks, everybody, for appearing.
That's Fremont County Judge Farron Edens wrapping up today's initial court appearance for Chad Daybell, who is now officially charged with 2 counts of destruction, alteration, or concealment of evidence. 2 major things came out of this. First of all, the bail that you heard about there. The judge setting bail at $1 million with several conditions, including if Chad Daybell were able to bond out, that he would have to wear an ankle monitor 24/7, and he would not be able to leave 4 counties in eastern Idaho. The really, really big fact that just came out was the prosecutor, Rob Wood, saying and acknowledging that the remains found, 2 sets of human remains found on Chad Daybell's property yesterday by law enforcement searchers, were the remains of 2 children. Of course, this whole case revolves around 2 missing children. Still has to be confirmed that these are the remains, but J.J. Vallow, Tylee Ryan have been missing since September. The criminal complaint lays out very clearly the timeline for that disappearance. And so that is where the prosecutor is now focusing. His argument for the stiff bail, $1 million, was that the circumstances surrounding the case require it, saying that the mitigating or aggravating circumstances, the aggravating circumstances in this case being that these are the remains of two children and that they are human remains, and that the charges only carry a 5-year sentence, but the charge is for destroying evidence. And so because the evidence in this case is human remains, the prosecutor asked for $1 million bail. The judge agreed and set it at that. Our Misty England is in Rexburg in Fremont County today. She has been covering this case and listening in on this.
Okay. So now my screen's looking all funny. Okay, there it goes. YouTube is acting crazy. And so I don't even think he should have got a bond. I mean, his lawyer, maybe better than Lori Vallows, but he sounded like an idiot there. Like, oh, Chad didn't try to run when they came to his house yesterday. Of course he couldn't run. Where was he going to run to? Fremont police was there, the FBI, or Fremont County, I guess, and then the Rexburg PD. Where was he going to go? He didn't run because he didn't have a chance. He didn't know they were coming. God, idiot. Got 2 kids buried in his yard. Now, I saw some people saying in chat, Lisa brought it up. Could Lori have not known her kids were dead? Yeah, that's possible. We don't know yet. He could have told her that he had them stashed at someone's house. I never thought about that. So I'm glad Lisa and I think someone else put it in the chat. I never thought about that. Anything is possible. Never know what's going to happen in these crazy cases. It's always twists and turns. Hey, Kimmy. He'll end up just like Fotis. Gosh, I hope not. I hope not. I wanted to see Fotis Dulo stand trial for murdering Jennifer so bad. But we're still going to get to see Michelle Troconis and Kent Malwini stand trial for conspiracy to commit murder. Weren't they already on the run to Mexico from Hawaii when Lori was arrested? I'm not sure, Cement Shoes. I don't know if they had plans to go to Mexico from there. They probably did. She's still a killer, so why does it matter? Exactly. She's still a killer. Those were her kids. She was responsible for them. So, in my mind, she's even more guilty than Chad because those were her kids. I'm not going to know what to think about it or what my opinion is going to be about it, though, if Lori didn't know her kids were dead and Chad said, I got them at someone's house. I'm hearing she went crazy in her cell last night. Did she go crazy because they were caught? Or did she go crazy because she didn't know her kids were dead? Also, something else I want to know, were the kids' bodies in that storage unit? Have they always been buried on that property, or were they somewhere else and then he moved them? Not very smart to bury 2 bodies on your own property, is it? God, they're a bunch of dumbasses. And if you got people killed, then your kids end up dead on your husband's property. Yeah. I really think that. I think she knew. I think they got rid of all these people so they could go off on their new life. And Lori was going to lead 144,000 people into heaven's gate. Jesus Christ. When I say that, I have to chuckle. I mean, it's just so stupid. It just amazes me that she could be that blind and that easy manipulated and controlled. It's just crazy. She got to be mentally unstable. She's probably never been normal. Love you too, Julie. Thank you again for super chatting me this morning, girl. It's so kind of you. I appreciate it. It's too much, though, girl. I think she knew. Chad and Lori thought the kids were zombies, such freaks. Exactly. I think none of us ever want to believe that a mother could murder her children. Or a father. Nobody wants to believe it. I don't want to believe it. But I really believe she knew the kids were passed away. Anyways, guys, I could sit here and talk about this all day long, but I have not gotten anything done around my house. I'm still in my PJs. I've not swept. I've not done anything. My dogs have not even been out since my last live stream ended because they've been laying down asleep. So I've got to get up and get moving. I got to go check on my goat and get some things done. If there's any more updates, I will let you guys know. Thank you for coming and watching. I appreciate it. I love you guys. Be safe. Be kind. I started to say I'm going to do a member stream this evening. I'm going to try to. Let me put it that way. I may not get to where, I've had a lot of time tied up into Chad this morning. So we may just do it tomorrow evening. But I'll let you guys know. Anyways, love y'all. Be safe. Be kind. Peace. See y'all in the morning.